Rahman.
Please make sure it's recorded too, Gabriel.
Yeah, we have recorded.
You're the reason my life's worth living. You're the reason I'm alive. I'd be lost without you. You're the reason that I strive. You're my destiny. You're my reverie. You're the reason that I breathe. You are all that I believe.
It's long for the people coming in. We're just going to give it a few minutes until we get some of our attendees, and then we'll start.
Sorry, since the music's going, gonna have to speak up a little bit.
I'm just saying we're going to give it a few minutes, one more minute, and then we'll start. Just let the attendees that are coming on join us, please.
है खुदा एक तेरा मेरा है एक फलसफा खरबदोश हूँ मदहोश हूँ तेरे इश्क में मैं शराबूर हूँ इलाही 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 मौला इलाही इलाही
You're ready?
इलाही मौला
Okay. Okay, Assalamu alaikum and Bismillah Rahman Rahim. Thank you for joining us. My name is Safura Khan, and we at Cornerstone Law Services are excited to begin this series of financial and legal tools for the Muslim family. So we understand that it may be confusing and sometimes intimidating when thinking about finances and legal services. So Hani and I wanted to offer free webinars to our community so we could educate them, we could educate our members about the tools and services that are out there and offer you all a chance to ask your questions in a comfortable space. And we'll be bringing in experts in different areas from time to time, and we want these to be interactive sessions where you ask questions that are important to you and let us know what you want to learn more about. I am obliged to mention that these webinars are not intended as legal advice, but for educational purposes, and to please reach out to a legal professional so that they can make a plan that's specific to your situation. So we will be presenting the tools that are available out there. And so hopefully you guys will get some good vocabulary and you can speak to the people you need to. And that way, you could be educated when you're choosing the best way, to have this work for your family. And so we plan to discuss estate planning today, and like all the components that go into an estate plan. And so that's our plan for today. And then can we go to the next slide, Honey? Eventually, in future webinars, our goal is to cover all these important documents like guardianship of minors. So in case you have minor children, and something is to happen to both parents, may Allah protect you all. This is actually a legal matter in California and other states, and it requires legal documents in order for the children to be taken care of the people that you choose. And so we'll discuss this in future webinars, inshallah. It's very important with parents of minor children. And then we'll cover power of attorney. We'll cover healthcare directives and HIPAA waivers in case you are incapacitated and somebody that you trust needs to be able to take care of you and make decisions for you. We will talk about trusts, the difference between wills and trusts. We'll talk about asset protection in case of creditors or even predators coming after your assets, which happens a lot in this litigious society. And then tax planning, We'll talk about insurances and like different types, disability insurances, funeral insurances, etc. Investments, so Sharia compliant investments, real estate, or other types. Planned giving, so sadaqah jariyah, and how that fits into your estate plan. And we'll talk about other financial topics, whatever is interest to you guys. We want to keep this interactive, and so different things come up, you have questions, and we want to be able to answer those in future webinars as well. So we'll start with the ayah from Surah Al-Baqarah, which talks about the importance of a will. So it says, the translation here is that a will, testament, is prescribed for you as obligatory. So you highlighted obligatory because we just want you to know that it's mandatory here. So when death approaches any one of you who is leaving wealth behind, that he should make a will testament in favor of his parents and near relatives, equitable in all fairness, and this is an obligatory duty upon the pious fearing Allah. So the point of this ayah is just that a will is a mandatory thing that every person should have. And so we will go into what a will is. Next slide, Penny. So a will is a legal declaration of a person's wishes regarding the disposal of his or her property or estate after death. So to make it a little more simple, it basically means that it takes an assessment of what you own, and you will appoint a person that you trust to dispense of those items and assets to the people that you wanted to go to after you have died, because a big maxim in our religion is that you can't take your wealth and your things with you. So when you leave, you have to leave it to certain people, and it's actually very well described in the Quran and Hadith. So that's what a will is. And it documents, so this is a document that designates your assets, money, homes, personal items to the beneficiary, the people that receive, your assets at your passing. And Quran lists percentages of our assets that are to be distributed to specific family members. And the importance of this is that it's important for us to make a real document, to take the time to make that document, and make sure that lists out our beneficiaries and how our assets are going to be distributed, and we have to prepare this document. So, and can go to the next slide, Henny. So the benefits of a will are here. I've listed 4. I'm sure there's many, many more since it's prescribed for us. But one is that we name the person who, so before I start this, I just want to let you know that if we don't make a will ourselves in the States, what happens is that the state we live in already has a will, a plan prepared for us as to how our assets will be distributed. And this is because, just as a backup, and it's well-intentioned, the problem is that the plan isn't always in line with our wishes and the Islamic methodology. So the first thing I have here is that the name of the person you will be able to name who you trust to manage your estate distribution. Sometimes if we don't name the person, it might go to somebody we don't really want to handle it, or it could go to the court to appoint somebody to handle it for you. And so we want to make sure it's somebody you want and you trust. Second, it will distribute according to Islamic laws of inheritance. So the nice thing is that the laws want to accommodate us. So if we write something and leave it like a legal document saying who we want it to go to, the state will honor it. It's just that if they don't know, then they have their own plan as a backup for us. Then we have, I see that we have a question asking what the state says. So I have those coming up in the slides, a couple of slides. I'll get to that. Then we have long-term care and provisions for children. So like I said, you get to choose who you would want to protect your children and take care of them and provide for them through the assets you leave for them in this world. You get to choose that, because if you don't have it, the state will appoint others or have to do background checks, and it takes time. And so you want it to be a smooth transition. And this is putting it in a will is a very good way of doing that. And finally, planned giving, you can, you know, like a sadaqah jariyah, like I said, you can leave a portion of your assets. Allah has provided for us to leave up to 1/3 to whoever we want that are not mandatory beneficiaries in our wills. So those are benefits here. So it's very important that we have to organize all our assets. So the importance of having a will, you know, can't be stressed enough. And then we have, you know, preparing a will requires a few steps beforehand. You have to organize your assets because there's over $8 billion in the Department of Unclaimed Property in the US. And this is partly because someone passes away without providing all the information their family needs to access those assets. So it's really important to do an internal inventory and accounting, you know, to have your real properties listed out, your personal properties valued and listed out, all your accounts together, retirement accounts, investments, all your insurances, and then also your debts, because the first things that, you know, can we go to the next slide? We have a priority of asset distribution in Islam. So once somebody passes away, all the assets are accounted for, and then you take out the funeral costs. So whatever it will cost to cover the funeral, your plot, your you know, family's services, all of that will be taken out of your estate first. Then any outstanding debts you have, those will be cleared with the rest of the estate. Then we go to the wasiyah, which is it's like a sadaqah jariyah, like I said. So up to 1/3 of your assets can be distributed to any organization, any you know, friends, anyone that's not mentioned as a mandatory beneficiary in the Quran. And so we'll talk about this more later. We have a planned giving webinar that we'll do and show you how that works. And then okay, so and after the wasiyah, then it goes to the mandatory beneficiaries. Yeah. So then a last will and testament can ensure that your wishes are respected when you die, but if it's not legally valid, then those wishes might not actually be carried out. And so to make sure that it's a legally valid will, we have to be 18 years old. You have to be of sound mind and capable of understanding your intentions for your estate. You have to understand what you want, who you want to be your beneficiaries, and your relationships with them. And then you have to sign the will and make sure that 2 witnesses at least that are not benefiting from your will are present at the signing. So the validity of a will depends on where you live and when you die. And so a last will, as last will and testament laws vary state from state, we have a network of estate planning attorneys nationwide, and, you know, just contact us and we can help with that. Now, how you can make a will, you can engage a legal professional, you can design one online, or, you know, you can even handwrite one. There's rules for just handwriting and signing. It's called a holographic will. But there's some dangers of doing it yourself, and we'll get into those. But for right now, for what a will does not do, we'll go back one more. So a will not protect against probate, which is a very big topic in will distribution. And Hani will get to that, talk more about that. It does not go into effect at incapacity. So there's actually a higher chance that we will be incapacitated in some way due to some accident or something. And so our will doesn't go into effect at that time. And so, and then also it doesn't protect from creditors. So creditors, people that can come and start claiming that you owe them something, whether they have proof or not, sometimes because it's a very public process, probate. So, you know, creditors can come in and claim rights over your assets. Okay, so some pitfalls of doing it yourself. So from the specific state you live in and the wording of the document to the required formalities for how it must be signed and witnessed, there's a lot of dangers in doing it yourself. So estate planning is not one size fits all. Even if you think you have a simple situation, it's almost never the case, especially with owning a home. It's very important to make sure you get this done properly. So you could have improper execution. So for a will to be valid, we covered that it had to be signed, witnessed, sometimes notarized. And procedural requirements are designed to prevent fraud, and many states may require that every witness on your will has to sign it in the presence of each other. There's little things that, you know, if somebody wants to contest it, then they can hold on to those like things that weren't done properly. There's higher chances of court challenges. Before the assets covered in a will can be transferred to your Islamic heirs, they have to go through the court process called probate still. And then during probate, creditors, heirs, other interested parties, they get the opportunity to contest your will or make claims against your estate. And so the do-it-yourself wills are more easily challenged than one that's made by a proper professional. And then sometimes, you know, you think that the will is enough, and it's almost never the case that it's enough to handle all the legal affairs and to know all the tools that are out there that could actually protect, you know, your family. For example, even the kids' guardianship. A lot of people don't know that you should appoint legal guardians for your children in case something is to happen to both parents, because they, you know, don't think about it. They don't know. They think, oh, my family will just take care of it. But here in the States, the court has to do a background check because they don't know who they're giving it to, and they could be responsible if they put the children in the wrong hands.
We have a process that we typically get into when a client, this is the first thing that we actually discuss, which is our kids protection plan process. So we have a very process thought out formula to make sure we protect our children, make sure that they are you know, raised by the people that you want and not end up in the foster care system. And we will, I'm sure we're going to discuss this in a next webinar just about the kids protection plan.
Yes, definitely. One of our very important tasks we do here. Okay, the next slide, please. Okay, so here to answer about what the state says, this is the California probate code. And so this is California's, all the states have their own probate codes. And so just wanted to show this as an example. So the first code here, 6400, says that any part of the estate of a decedent not effectively disposed of by a will passes to the decedent's heirs as prescribed in this part. So this is just to mean that if you don't have a will, then this is how it's going to be disposed. So here we have 6401. So it explains that the first part is, as to community property, the intestate share of the surviving spouse is 1/2 of the community property that belongs to the decedent under section 100. So we have a thing called community property here in California, which is any property that's obtained after marriage is to be split 50-50. So 1/2 of the community property automatically goes to the spouse, and then 1/2 of the community property will be disposed of in whatever way the other spouse wants it to be. Then as to quasi, and the second part is as to quasi-community property, which is any property obtained after marriage in any other state besides California. They still consider it to be a community property. So it's the same thing. Basically, it will be split into half. And then it continues to say, as to separate property, so the share, the half that it belongs to the person that is to pass away, the intestate share of the surviving spouse is as follows. So in the California intestate law, the entire state, if the decedent didn't leave any parents, issue, meaning children, brothers, sisters, or there's nobody else, then the entire estate goes to the spouse. Then 1/2 of the intestate, 1/2 of the intestate estate will be given to the spouse, surviving spouse, when the decedent leaves only one child, or the issue of one deceased child, meaning like grandchildren. So if there's only one child or any grandchildren from that one child and that he's passed away, he or she, then half the estate goes to the surviving spouse. Next, when the decedent leaves no issue but leaves a parent or parents, or the issue or their issue, meaning the brothers and sisters, or the issue of either of them, so whether they're step brothers or step sisters, then also one half goes to the surviving spouse and the other half will be distributed between those brothers and sisters or step brothers and sisters. I mean, half brothers and sisters. And then 1/3, if there's more than one child and all of that happens, then 1/3 is given to the surviving spouse. And this is, all of this is, you know, well-intentioned, but it is in contrast to our Islamic distributions, which is the spouse will get a 6th or an 8th, or, you know, surviving spouse usually. So just wanted to show the difference between the state's plan and, you know,
the issue is that they have to go through this probate process, and this is a very lengthy process. We'll discuss it in a minute, but you know, on average, as you know, so far in California, it takes anywhere between 12 months to 16 months. During this time, the families, they're all stuck in this horrible process. So it's very
that 12 to 16 months is only if there's no contests and no disputes.
Absolutely.
If any disputes and contests happen, it could be like, I mean, we know of cases of 10 years of conflict, and people have, the beneficiaries have not gotten their, you know, inheritance yet.
Yes.
Okay, so in addition to the legal requirements, we as Muslims, we need to think about Islamic requirements as well. For example, the requirements set out in the Quran about distribution. So these can get controversial sometimes because, you know, we have distributions that are different for daughters versus sons and are mandated rather than left to our discretion. So they're mandated to us, and so it's not really up to us. But this is, you know, a sensitive topic, but we're dealing with death and accountability at a very sensitive time, and it's not something that we should avoid. So there's no issues with gifting in lifetime, and this is a method that some have adopted in order to minimize discrepancies in the distributions between their children. But there's all different types of methodologies, you know, and some people have made the decision to just forego the mandate and distribute equally, which we don't encourage. But, you know, like when you have all the options out there, you understand, you talk to a professional, you can make the proper decisions for you and your family. You know, we really encourage you to discuss with your religious leaders and legal professionals. And we can also, you know, arrange, and in Quran, we have distributions for parents, we have distributions for spouse, we have distribution for children, and if none of those are alive at the time, there are contingent beneficiaries. So, and with wills, you can even arrange for distributions to be made at different ages and stages, so the children don't receive their inheritance outright at a young or immature age. So you can have it at, you know, 25, 27, 30, or you can even do it like at graduation, at marriage, etc. And then personal items like cars, jewelry, etc., should also be taken the time to be valued and then distributed properly to avoid conflict in the family at an emotional time. A lot of these things can be very sentimental, and families can start fighting, and there are a lot of fights at this time. And so to avoid that, it's just good to put some thought in and, you know, distribute them properly beforehand. So overall, it really isn't our responsibility to decide who gets what or how much, since Allah subhanahu wa ta'ala made those decisions for us. But it's our responsibility to make sure we carry out the duty, actively make a will, because to not do it here in California or any other state would automatically be contrary to the way we're supposed to distribute our assets. And if you have yet to do any estate planning, we have do-it-yourself document, you know, or you have do-it-yourself documents, you know, you're not sure about, or you have a plan already, but it's outdated, you know, you can bring it in. We can check your Islamic inheritance laws, and we can check with, you know, the statutory requirements in the state, and do a free review of your estate to make sure it's legally valid. We can evaluate your estate plan. and ensure it will protect your wishes and provide for your family according to your wishes in the case of your incapacity, or may Allah protect you, but when you die. So with that, I will transfer it to Hani.
Thank you. Thank you, Sephora. So you know what? I'm going to be talking about the differences between wills and trusts. But before I do that, thank you for explaining the will side aspect of things. And, I want to kind of briefly explain what does it mean by a trust. So a trust is a legal creation, set up to benefit someone or something. For example, some people set up trusts to benefit their children, their grandchildren, or even charities. So it's easiest to understand if you think about three separate people being involved in the process of setting up a trust. One person is called the grantor, or in the event if you're a married couple, so both spouses would be the grantors. They fund the trust somehow by placing money or any other assets into the trust. So any type of assets may be used. You can use money, you can use bank accounts, cars, or even obviously real estate. The second person, who is known as the trustee, agrees to manage the assets. Once the assets are in this legally created trust, the trustees hold title to the asset. Now we have the third person, who is known as the beneficiary, and they receive the benefits of the trust. For example, the benefits might include a monthly allowance or even a place to live. How the trust is drafted and who plays each of these three roles depends on the goals of the person who's trying to setting the trust up. You can call our office and schedule a family wealth planning session. This is our initial step in our process of setting up your estate planning documents, where we basically explain trusts further and help you, inshallah, identify the best strategies for you and your family. So now that takes me to basically the differences between wills and trusts. Again, when discussing estate planning, a will is what most people think of first. Indeed, wills have been the most popular method for passing on assets to heirs for hundreds of years. But wills aren't the only option, and if you rely on a will alone to pass on what matters to your family, you're guaranteeing, as Sephora mentioned, you're guaranteeing your family has to go to court when you die. This is exactly what we want to avoid this horrible probate process that Sephora discussed, and we'll go over it in a minute as well. But basically, there are other estate planning vehicles, such as trusts, which used to be available only to the uber wealthy, but they're now being used by those of all income level and asset values to keep their loved ones out of the court process. So determining whether a will or a trust is best for you depends entirely, on your personal circumstances. As Sephora mentioned, this is not a one-size-fits-all approach. It has to be customized to your own family situation. And the fact that estate planning has changed so much makes choosing the right tool for the job even more complex. So the best way really for you to determine the truly right solution for your family is to meet with one of our family protection lawyers for a family wealth planning session. And during this process, we'll take you through an analysis of your personal assets, what's most important to you, and what will happen for your loved ones when you become incapacitated or die. Again, this is when we meet with our clients, this is really not about you. It's about your children. It's about your family. It's about the people that you love. It's making sure that they receive everything as easy as possible and avoid this probate process. So it's about them, when you become incapacitated or when the time comes. So inshallah, this way, we'll walk you through this process so you can make the right choice for the people you love. But here, in the meantime, here's why having just a will is not enough. So, your family must still go to court, as we mentioned, and this is something very important. So we're going to keep repeating that. While you may think, and it's a very, one of the biggest misconceptions in our community that, we think that a will is enough. And when we ask, do you have your estate planning documents? Alhamdulillah, I have my Islamic will. So while you may think that having a will allows your loved ones to inherit your assets without the court intervention, this is really not true. For your assets to be legally transferred, to your beneficiaries, your will must first pass through the court process called probate that Sephora just had explained. So a probate process can be extremely, distressing for you or loved ones. The proceeding is very lengthy, can drag out over months, at a minimum, months to even years. And in most cases, your family will have to hire an attorney, which means more legal bills that can quickly drain your estate. For example, at a $1 million property that our office had to go to probate for one of our clients, open up probate for them. The attorney's fees alone were about $25,000, and these are statutory fees. I mean, this is not our fee. This is just already set by state law. So, the other issues with probate, that the probate process is a public process. So anyone can get online, they can find out exactly what are the value of your estate. They can also learn, what and how much your family members are going to inherit, where they live at. So really making them targets for frauds and scammers. The other issue with only having a will, that the will does not protect against creditors, lawsuits, or even poor decisions that your beneficiaries end up making. So passing on your assets using the will leaves those assets vulnerable to several potential threats. If your will distributes your assets to your beneficiaries outright, for example, those assets are not only subject to claims made by the beneficiaries' creditors. Creditors can go after these assets that the beneficiaries inherited, but they're also vulnerable to lawsuits and even the beneficiaries' own divorce settlements that the actual beneficiaries might be involved in. For example, a child receives an inheritance that gets deposited in a joint account between the child and their spouse. In the event of a divorce, now the ex-spouse can take 50% of this inheritance because it has been commingled. So it's really not protected from any creditors that can go after the beneficiaries in event of, for example, even the beneficiary getting in a car accident. If they receive their inheritance outright, they put it in a bank account, then creditors can go after this bank account. Just like an ex-spouse can go after bank accounts as well in the event of a divorce, because the assets has been commingled. So it's important to kind of think about how you can transfer your assets to your beneficiaries in an asset protection trusts. And these are some of the things that we focus on. We have our asset protection lawyers, our CPA tax associates as well, that basically explain how you can protect your inheritance, where your children can get it in a lifetime asset protection trust to protect the children from any creditors or even their own divorce. And we'll talk about that in many more webinar series, inshallah. The other thing is a will does not offer any protection against incapacity. So a will helps ensure your assets are properly distributed when you die, but it's not valid if you become incapacitated. 1 out of 4 people, they're driving and they get in a car accident, they're in the hospital, they cannot communicate. They're not dead, but they cannot communicate. So even your own spouse, even having a will, your own spouse basically would not be able to make medical decisions on your behalf should you become incapacitated. And that's only when you have a will. So there's other vehicles or other documents that we put in place to make sure that your trust plan is also, or your estate planning documents protect you in the event of incapacity. And the last thing that I want to discuss is really does not, the will does not cover all the assets. Some assets cannot even be included in a will. For example, it will only cover assets or property owned in your name only. It does not cover property co-owned by you with others listed as joint tenants. Nor does it will cover assets that pass directly to a beneficiary by contract, such as a life insurance policy or retirement accounts. So, it's important to not let your plan fall short. It's important that, again, as I mentioned, the will is a very important part of your estate plan. But again, a will is almost never enough by itself. So it's important to combine your wills with other planning vehicles, such as living trusts, to provide a level of protection and avoid any, gaps or any blind spots, So if your plan is here's the issue. If your plan is incomplete, it's your family that suffers when the time comes after you're gone. So that takes me basically to the probate process that I just talked about. How do trusts affect your taxes? One thing that a disclaimer here, we have our associate CPA tax lawyers, we have our senior CPA tax lawyers. So Sephora and I, we're not CPA tax lawyers, but we have our CPA tax lawyers that are very experienced and they can advise you on this. But I'm going to discuss it briefly, so because many of our clients, come to us curious, confused about trusts and taxes. Today, inshallah, we're going to kind of sort it out and clarify things for you. So there's really, two types of trusts, and each have different tax consequences. You have revocable trusts, and which are very, more commonly used. Basically, they have no tax consequences whatsoever. So a revocable trust has your social security number as its tax identifier. And it's not a separate entity from you for tax purposes. It's a separate entity from you for purposes of probate, meaning that's after your death, when you're becoming, either become incapacitated or die, your trustees will take over it basically without a court order, as I mentioned, and keeping them out of the court. But until your death, it's treated as invisible, as an invisible structure or vehicle from a tax perspective. So at the time of your death, if your revocable trust provides for the creation of irrevocable trusts, then the tax implications will shift. And this is, again, when you have to do some advanced planning, when you have to create sub-trusts that are irrevocable in nature to protect the surviving spouse, to protect the children at the time of your death or incapacity. Let's say you're in a highly risky profession, you're a physician, attorney, engineer, or any business, you're in a business that is very high risky nature. You just want to make sure that when you leave your assets, you leave it protected to the surviving spouse. Because if you just give it to the surviving spouse in a revocable trust, now creditors can go after these assets as well. So we could go over basically all this, the design of a trust in our family wealth planning session, but just we'll also discuss it in next webinars as well. But when you have an irrevocable trust, either created during life, obviously you can create it during your life too, or at death through a revocable living trust, or even through a will that creates a trust, that trust has its own EIN number or employer identification number, also called the TIN or taxpayer identification number. Generally, it pays income taxes on income earned by the trust, as if it's a separate tax-paying entity. The last thing I want to basically discuss is estate taxes. Currently, if you die with assets over 11.58 million, as an individual, or 23.2 million if you're a married couple, then your estate will be subject to estate tax, and any amounts over that 23.2 million if you're married couples, or if you're an individual, it's 11.58. And the rate that you would have to pay, it's a 40% hit on any assets that are above the state tax exemption. Yep, I mean, it's 40% will go to the government.
And then Hani, right now it's at a very high number, so it may be not affecting a lot of people, but eventually with changes in government or changes the number fluctuates, right?
Absolutely. This is not a fixed number. I mean, there's really three things we'll never know. I mean, obviously, when are you going to die? How much assets are you going to have when you die? And what would be the state tax at the time of death? For example, in 2001, that state tax was only 1 million. So you would have to pay almost 40%. Your family, your state has to pay 40% on any assets that exceeded that number at that time. So it's important to keep a flexible estate plan in place that can account for estate taxes issue should they arise. So if you're trying to figure out whether an irrevocable trust or a revocable trust or even a lifetime asset protection trust is best for you and your beneficiaries, as I mentioned, our CPA tax associates that are currently draft all our plans. Sephora and I were focused on the educational side of educating our community, the Islamic side of it, making sure that, you know, it's very important documents. We want to be your family protection lawyers. We understand our community and we want to make sure they understand how important these documents are. So again, we can help you evaluate the decisions and make, you know, the right choices for yourself and the people you love. So the next thing I want to talk again, and this is, as we mentioned, but basically, you know, there are 6 ways that trust is better than a will. Again, as I mentioned, the will is one of the most estate planning documents, so most basic estate planning documents. So I just want to get into it right now. So again, the avoiding probate or conservatorship, a trust will bypass the probate process. And this is a whole purpose of setting up your estate planning. It's not an asset protection if you only have a revocable trust. It just protects you from this probate process and make sure that, you know, that your trustees are carrying out instructions. So basically the will, when you have a will alone, a probate must be open in your county court. And that means, you know, your family is stuck dealing with this court process if you get incapacitated or even you die. So it also, you know, you want to discuss about how is it providing for a person with special needs. So if you have a child or another dependent with special needs, a trust, commonly known as a special needs trust, can protect assets for a special needs person without risking their qualification for government benefits. So it will allows you to transfer assets to a special needs person, but will not protect those assets from the government. Also privacy, as we mentioned, since a will has to undergo this probate process, it becomes a public record and a trust is private. And we want to make sure it remains privately handled, you know, with your professional, with your lawyer. So, you know, very important topic too, blended families. You know, if you're a part of a blended family situation, you know, a trust can give you the flexibility. You will want to make sure that the children from any prior marriages are also provided for in the way you want. You know, we have so many cases, I'm sorry, there's so many cases that we, you know, hear on daily basis where, you know, what was supposed to end up going to children ends up going to actually to a new spouse, and the children don't receive anything. So it's important to have a trust that basically distributes your assets properly. You know, any out-of-state property, if you own property in another state, you can more easily transfer ownership via a trust than a will. You know, transferring out-of-state property in a will usually means, you know, additional legal expenses because you would have to open probate in multiple states, and that is, I mean, that's not fun. It's not a fun process for the people you love. And the last one is asset protection. So if you want to protect the assets, you leave your loved ones from creditors, including bankruptcies and divorces. A trust is the way to do it. It's a gift, really, that you can give your loved ones that they won't be able to get it any other way, or they cannot even give it to themselves. So as your family protection lawyers, Fura and I, we would offer expert advice in wills, trusts, and numerous other estate planning vehicles. We also use proprietary systems such as our family wealth inventory and assessment portal. This is a very important, as Sephora mentioned, there are $8 billion in the State Department of Unclaimed Property and $58 billion nationwide. And it typically gets there because, you know, one family member dies and the rest of the family, they don't even know all the assets that they have. I mean, that this person had. So, you know, you get assets that, you know, the family members would miss a bank account or a real estate property or a 401, you know, retirement account. So it's important to have a family wealth inventory where the whole family know exactly how much assets they have to make sure that nothing gets in the hands of the government. So in the system, basically we have AI features. We also that help us basically carefully analyze both of your assets, you know, tangible and intangible assets, to help you come up with an estate planning solution that offers maximum protections for your family's situation. So I'm gonna go into the actual system that we have. So basically, it's a digital estate planning software. It organizes all your estate and your life. It has access to vital information. You get the peace of mind through a very modern, again, with AI features in it that allows to identify gaps and holes in your financial, any of your financial assets. So a little bit more about it. So it's a portal that provides instant access to documents, to all your legal documents. You'll have instant access to it, instructions and any important information, not only just for estate planning. And I'll show you how would your portal look like when you become one of our clients. So it's accessible on any device, mobile devices as well, to help anyone navigate through these crucial moments. It's also a way for you and your loved ones to have, as I mentioned, easy to understand illustrations. We have charts that explain exactly how is the Islamic distribution, how much is it, what are you going to get, when you do the percentages, when you split the Islamic percentages, what is the total estate, your own state, to get you, financially organized. And that all assists you, again, as I mentioned, with understanding how the state will be transferred as well. So it has a digital vault that ensures all your important documents will be safe, secure. It's very secure platform, and it's accessible anytime and anywhere. It's also one of some of the features, simpler, safer software that will provide direct communication so that changes can be made as your life changes. It's a way to preserve your legacy, not only your your material stuff, but we also have your more important stuff, your spiritual assets, your intellectual assets. It gives you the features to share photos, videos, memories, messages from generation to generation. This is such an important topic that we miss all the time. For example, when my dad, this is a personal story that I'm going to share with you. When my dad passed away in 2006, I had a voice mail on my phone, basically voice message from my dad saying, Hani, give me a call. And this is something that I saved in my phone forever. Then someday when something happened on my phone, basically I had to change service. That voicemail has been disappeared. So imagine if you have a portal that you can actually you leave messages to your children. It's a video, leave some videos. And this is really important. I mean, for me, that was the reason why we invested Sephora in this platform as well. And the last thing, things happen when you travel. If you're overseas, you're stuck, or, during these times, or even during normal times, you lost your passport, or you have an auto accident, or home damage, flood, fire. So if you need instant healthcare information, it's never a problem. You can access all your vital information and important documents and moments from anywhere. And this is how your portal will look like. Sephora, if you want to add in to it.
I'll just, so this is an example of what, when you sign in with your username and password, and you would get all your, you could go, these are all icons here. You would press, and then you would get to see, all your financial assets, for example, listed out here, all your real estate, your investments, all your business investments here, those would all be organized. And then your insurances, so we have life insurance here, we have prepaid funeral expenses here, we have disability insurance, long-term care insurance, all of it would be organized here, all the policy numbers, all the information you need, beneficiaries, everybody. And then there's, any of your retirement, pension, survivor benefits here, all your legal documents, meaning your estate plans, your healthcare directives, your power of attorneys would all be filed under the legal area. And then down here, you would have all your tax information and all your miscellaneous final instructions. These are your legacy type things that Hani was mentioning, your videos or your photos or something you want to, just values you want to leave eventually. And then there's an area where there's, you put in all your passwords and things so that, eventually they can access it, because sometimes the beneficiaries can't even access them once, they don't have access to you anymore. So
And I have a question, Sephora, too, for in a chat, basically from Brother Taymur. Is he asked, does one need to keep a running list of assets? So this is the right time to answer it. And is this updated monthly, quarterly, or year? So when in our trust plans, we do a yearly complimentary review, and we go over this portal. If you see, if you have had updated, obviously, whenever you update something, you can let us know. We can put it on the cloud. But we would also do at a minimum a yearly review to kind of go over these, update your assets as well.
Right. And so we don't do I mean, our area of focus is estate planning, but which would be in the legal section, but we have, you know, connections with very good experts in areas of insurance and areas of investments and areas of, you know, retirement. And so, you know, we have partners that are very, very experienced and can go over anything that has you're missing or you want to add. So this is, you know, a very good the way, just a method to, you know, organize your financials in a secure area that you have access to anywhere at any time.
So really, I mean, the bottom line is our mission is to be your family protection lawyers. So we will give you access to our resources, to our affiliate partners, to take a second look at your financial assets, your 401ks, your insurance policies, to make sure that they translate these financial documents for you. They do it free of charge, a complimentary, but it's good to have that second look, or basically second review, just like we offer second reviews on your estate planning. We understand, we get it. These are complicated documents, you know, whether it's your trust, if you have set up one already, or if you have any other financial assets like 401k. So we want to make sure that there's someone who's very experienced, a consultant that can basically translate all these financial documents and explain it, break it down to you.
Yeah.
So I think
if there's any other questions, please post them here, or eventually we'll give you all our information and we will get back to you through email or.
Yeah. So if you, you know, really, if you like to learn more about the use of trusts to pass on what you care about to the people that you love, you know, you can call our office today, schedule a time for us to sit down and talk. We normally charge $500 for a family wealth planning session, but because this planning is so important to us, because we want to make sure that your family has these documents, we've made space for the next 5 people who call us this week to schedule a virtual Zoom meeting this week, where they can get the family wealth planning at no cost. And they would also get a $250 basically coupon. So that's a $750 total savings. You know, when you mentioned basically that you've been on this webinar, and we'll go through your family wealth planning session. So I will post basically our Calendly link where you can go online and schedule your appointment, or you can also call our office, and I'll send our office information as well.
So we have a question also from Mitch, and he says that he's already has a trust that through Cornerstone Law Services. So thank you very much. But he's asking on how he can also get onto the portal.
Absolutely, Mitch. You think I'm not going to give you that access? Yeah, so this is something that we just actually invested in, and we're just tying it up, making sure that it looks great. So inshallah, I will be reaching out to you and to all our clients that already has, you know, has done their estate planning with us. So I'm just gonna, in the chat box, go ahead and post.
I think we have a slide.
So this is our client testimonials. You know, please take a look at this. And here's our office number to contact us. And you can actually schedule a meeting online as well to set up a family wealth planning session using this link that I'm sharing with you now. And any questions, any other questions? Not sure if I missed anything, but I think it's good timing.
Okay, let us know what you guys would like to hear more about or learn about, and we'll try to get those, you know, things answered for you. Anything like retirement funds, whatever you guys have questions about, insurance.
Okay, I think we answered all the questions. There's a new message here. What is Sephora's cell phone number?
That's from
Okay, so Dr. Sana,
Sana's trying to get my number. Um,
okay, sounds good.
okay, then. Oh, there is a question here. If my assets go to probate, what do heirs have to prove?
Where's it at? Yeah,
It's
I'm
in
sorry.
the questions.
I'm still trying to answer Dr. Sena's question, but I just don't have an answer for it. So I'm just going to move on to what was the question for?
It says, if my assets go to probate, what do heirs have to prove in court? So it's actually not so much that your heirs have to prove anything. They will probably have to just prove their identities with some type of identification card. But probate, basically, it's an assessment of all of your assets, and then they give some time for creditors to come and claim their debts from you. And then they also inventory, they do appraisals, and then they make a report, and then the judge has to just know identities and relationship to the deceased, and then they distribute it, and they hire an administrator to go distribute it. So that's why all the costs go into paying for all of these services, reports, and people that are doing these services. So that's a
Time-consuming process.
yeah, it takes a lot of time and it takes a lot of money.
And then really what they have to prove, I mean, that's a great question. They have to prove that basically they have to convince the judge that they're the right person to distribute your assets. And but I mean, here's the issue with that. Now the judge has to make decisions on who is the personal representative, who's the executor of your state. And sometimes, judges don't know. I mean, they base their decisions on financial statements. They base on who has a better credit. But you know what? So that means that the wrong people can end up actually distributing your assets. And this is a problem with that. The last thing you want is to make sure that your family or to make sure that your judge, I'm sure anybody you choose would be a better choice than having a judge that don't know your family end up making these decisions for you. And obviously, as Sephora mentioned, it's a time-consuming process. It's a very lengthy process. It's really, you just never want to put your family in this horrible situation. So I think we're good. Jazakallah khair everyone for attending. We're looking forward to meeting you next Sunday at 10 a.m. Please share the link, family protection lawyers, and Jazakallah khair everybody.
Thank you.